When you start your divorce in the state of Nebraska, generally speaking, the fastest that the case can finish is approximately 61 days. When you file, you have to file multiple documents, and then you have to serve the other party. So whenever you start a lawsuit, you need to serve the other party. Once service is perfected, or that portion of the case is done, then that starts a 60-day clock. It's a mandatory cooling off period in the state of Nebraska. So you can't finish your case until after that cooling off period is expired. But if the parties are in agreement on everything, then you can file your decree on the 61st day. So you'll be divorced on the day that it is signed and entered with the court in the clerk's office. However, there is a 30-day appeal period that starts on the date after the decree is filed that has to expire before it's a final order. Generally speaking, that 30 days doesn't affect the parties. 61 days is approximately the fastest that you can get through a divorce action. So if you and your spouse are contemplating divorce and you're trying to sort of plan out the events and what it's going to look like, the fastest possible fast track that the divorce can happen, which is 61 days. But generally speaking, I'd say that if the parties come in and you have a relatively good idea of how you want to address and divide your marital assets and debts, and there's not a significant amount of controversy or argument with related to custody of the children, to the extent you have minor children, then the case can be done in about 6 months. If you are a newlywed couple and there just hasn't been a lot of time to accrue items or debt, then those cases really can be done closer to the 3-month mark, assuming that the parties are quick to get us the information that we need. The legal steps in divorce are basically that you need to file the initial documents, the filing of a complaint, confidential party information, vital statistics worksheet. You file those documents with the district court clerk. At that point, you need to serve the other spouse. Service in an uncontested divorce would occur likely with what's called a voluntary appearance, which waives the necessity of a sheriff serving that person at their home or workplace. Otherwise, in a more contested scenario, you have to serve them with the sheriff. Once service is perfected, then you have a 60-day cooling off period. Once the 60 days are up, the parties then move towards finishing out the case, whether it's with mediation for a parenting plan, or to mediate the assets, or to enter a final decree. In order to enter a final decree without having to go to court, the parties sign off on a stipulated waiver of the final hearing. When you're filing a divorce, there's 3 documents. The main document, the one that actually starts the lawsuit in the district court, is called a complaint for dissolution of marriage. The complaint is a very generalized document. In the state of Nebraska, we use notice pleading. So that document itself, while it is the one that starts the case, doesn't have all the details that maybe you or your spouse have previously discussed that you would like to divide. It's going to be more generalized, but it hits the statutory factors that you need to actually get divorced in the state. After that, you have what's called a confidential party information worksheet and a vital statistics worksheet. These documents are sort of a culmination of all of your personal information: your name, full name, middle name, last name, email, home, social security number, your race, ethnicity, where you were born, where you were married, a lot of that confidential information that you necessarily wouldn't want to be out and as part of your court file. Those are required filings. We file them with the district court, but they get split off before they reach the court file, and they're just used for statistical purposes. If you or your spouse are in a position that you're contemplating divorce, or if you have some issue that you think may lead to litigation, mediation is oftentimes a really good place to start. When you mediate, or mediation in general is just a neutral third party that's going to sit there and sort of provide you guys with assistance on trying to reach agreements on any outstanding issues that you may have. The mediation process itself can be relatively quick. It can be done in a number of different ways. You can mediate in the same room. You can mediate over Zoom. You can mediate in separate conference rooms, and the mediator can come back and forth. But overall, mediation provides the parties with a less formal setting, and a lot of times a lot more comfortable setting for them to sort of speak through their difficulties and try to find common ground so that you can avoid costs and the expense and just sort of the anxiety that comes with litigating through the court. If you or your spouse have any questions about what to expect when going through a divorce in the state of Nebraska, visit us at huskerlaw.com.